Hi, good evening. Good evening. Um, Hi, good evening. Today we were supposed to talk about. I was really quiet all day. We were supposed to talk about um, CJ Sereno's impeachment because today there's an article in the Philippine Daily Inquirer written by Oscar Franklin Barcelonatan, and he did a review of the CJ's answer, CJ Sereno's answer to her impeachment complaint. And he also did an initial review about what her defenses are. Primarily, the problem with CJ Sereno's answer is that she basically admitted to a lot of things that might send the impeachment to the Senate. The second was, I spent the afternoon with a gentleman named Juan Ponce Enrile in his home in Makati, and we talked a little about history. One of the reasons we went to talk to him was really spurred by the interview he had with Lucy Cruz, and I found that it was super bitin, that he wasn't given much of an opportunity to answer. So we wanted to ask him about martial law, and so one of the things that I'd like to talk to you about today is his ambush, because that was the one thing that was brought up during that was one thing that was brought up during his interview, and he didn't have a chance to really explain it. So we'll talk about that one. The other thing that we'd like to talk about is the perspective. Well, last week was kind of depressing for some of us who are supportive of the Duterte administration, because the president has been feeling the burdens of office. But so one of the things that we asked Senator Enrile is if you could advise the president, what would you advise him? And he said, I would never presume to advise the president, but he said something to the effect, well, actually I have everything on tape. He said he's doing a good job and he is doing it right. And so we will discuss that later on in light of his the back and forth answers between him and the Office of the Ombudsman, and all of the commentary that has been coming in. So let's begin. In the Philippine Daily Inquirer today, the Oscar Franklin Barcelonatan, who is a legal commentarist in the Inquirer, says that basically Justice Sereno admits what she had done in the very specific charge of her partiality in her conduct during the course of the Judicial and Bar Council evaluations of candidates. The Judicial and Bar Council, as you know, is a constitutional office. It's the body that recommends to the president, gives the president a short list of judges and magistrates and justices for the positions to be filled. The president makes the appointment, but the short list is created by the JBC after they have conducted the evaluations. Okay. But before we continue, please don't forget to share. Okay, so those who haven't shared yet, please go ahead and do so. No, I'm not going to make taray today. All right. So the case of Justice Sereno, one of the most serious charges in her impeachment case is this. And understand this, that Justice Sereno had already submitted her answer to the Congress, and basically her answer admits what she had done in the complaint. The complaint says that she had acted with partiality okay, let me just get that. The case says she had acted with partiality in evaluating now Justice Hardelesa's application for position as Associate Justice in the Supreme Court. Oscar says that, so by Sereno's own admission and as documented in the Hardelesa decision, she was the accuser. And then she ruled on her own accusation, single-handedly deciding the case because of the unanimity rule. So she was prosecutor, judge, jury, and executioner all in one. The Hardelesa case went like this. Hardelesa was the Solicitor General during the time of President Aquino. We've talked about this in one of the previous ones, so I'll make it a really, really short review. Justice Hardelesa, at the time was Solicitor General. He applied for the position of Associate Justice, and during the course of his evaluation, somebody submitted a challenge, an integrity challenge. An integrity challenge means you will bring up an issue against the candidate pertaining to his or her fitness to the office based on integrity. Okay, like there's a case, there's the most common ones are things like immorality, that you have been charged with something, etc. In the case of Hardelesa, Justice there were several integrity issues that were brought up, but the person who brought that up was Justice Sereno herself. Now remember, the Judicial and Bar Council is headed by the Chief Justice. And there are several people on the JBC, a representative from the Senate and a representative from the IBP, etc. So there are several members of the panel, but the head of that council is the Chief Justice. And the Chief Justice was the one who raised the integrity issue. And in doing so, instead of inhibiting herself, you see, when issued a challenge on an integrity issue, it has to be unanimous. The candidate must get a unanimous approval vote from the body in order to maintain your slot, in order to be nominated for the position. What Justice Sereno did was she did not inhibit herself, even if she was the complainant. That was one. Second, she also did not give Justice Hardelesa an opportunity to answer. In other words, he was told to appear before the Judicial and Bar Council. He was told right there and then that there were integrity issues against him and required him to answer right there and then. But the rules of the JBC are very clear that the person must be notified in writing and must be allowed to answer in writing. Nevertheless, because Justice Hardelesa was being compelled to appear before the council and to give answers impromptu, he just refused to show up. So what the JBC did under the direction of Justice Sereno was to continue with the meeting and then they voted on him, and of course she opposed it, meaning that the council could not vote unanimously for Justice Hardelesa. So the reason this is such a serious charge is because Justice Hardelesa filed a suit against Justice Sereno. And he filed it in the Supreme Court and he won, which is why he is now an Associate Justice. The more striking thing here is that this is now a decision of the Supreme Court, which means that basically what is in the decision of the Supreme Court are essentially proven facts already. So there is nothing to disprove. Now we also heard that Justice Sereno has asked for an opportunity to cross-examine the witnesses against her in Congress. What does this mean? What does this mean? When Justice Sereno said that she wanted an opportunity to cross-examine witnesses, this is beyond the usual procedure in the Committee on Justice. Why? The proceedings in the Committee on Justice, and in fact even in the House, are similar to what we call a probable cause hearing, which is akin to what happens when you have a hearing in the office of the prosecutor. So when you file a criminal case, you file it in the prosecutor's office. The prosecutor then will get the complaint. If on its face there is a reason to conduct hearing, they will send a notice of the complaint to the respondent. At this time, the respondent, the person you're accusing, person accused comes to the hearing and submits his counter affidavit. And then the complainant is given an opportunity to file his reply, and then the respondent gives a rejoinder, and then the complainant gives a sur-rejoinder, and then it is submitted. Sometimes the prosecutor will say, no, sige, hanggang answer lang, okay, hanggang reply affidavit lang, or rejoinder lang, etc., and then no more. So what you can see is there's no opportunity to cross-examine when it's a probable cause hearing, because it's usually what we call a table investigation. Affidavits are given, and then the documentary evidence is attached, and then the parties, they subscribe, they swear to their affidavits, and then it's submitted, and then the prosecutor makes a determination whether or not there is what we call probable cause. Probable cause means that there is a crime probably has been committed, and probably is determined by the standards of a reasonable man. And then if the respondent is the person who probably committed that crime. So this is not, they're not asking you to submit evidence beyond reasonable doubt. This is just enough evidence to see if the case should go to trial. Now, that is what the Committee on Justice is conducting, similar to a probable cause hearing. So in a probable cause hearing, you usually have answers, a complaint affidavit, and then an answer, a reply affidavit. And then if the committee believes that you need to elucidate it more, then they allow the complainant to comment, and then the respondent will comment again. In this case, what Justice Sereno is asking is for her to be able to cross-examine the witnesses. Why is this irregular? Because you're not here to try to prove reasonable doubt. You're not here to try to prove guilt beyond reasonable doubt. It's just a probable cause hearing. Second, it's not a trial, and in a trial, you have the right and the opportunity, given the opportunity to confront your witnesses, to confront your accusers. Kasi it's one of the rights of an accused is to be able to confront or be able to see at least the person who has accused you of a crime. Yes po. Hi everybody. I'm sorry if I haven't had the opportunity yet to go through all of the greetings. So, why is this highly irregular? I'm not sure if the Committee on Justice is going to allow her to cross-examine the witnesses, but if they do, it's highly irregular. And we can also see that this doesn't seem like it is. It seems completely out of place. You know why? It's a probable cause hearing. If the facts and the evidence that has already been adduced indicates probable cause, then this is voted upon by the plenary. The plenary will decide, oh, sige, there's enough evidence, then this will go to the Senate for trial. At trial, that's where she has the right to confront her accusers. That's when she has an opportunity to cross. Now, some people are saying the reason she's asking to cross-examine witnesses here is because it is very intimidating. Particularly, di ba, kasi normally yan, affidavits lang yan, di ka naman kinocross dyan, and you can raise several points just by answering the complaint affidavit. But cross-examining, allowing her lawyers to cross-examine a witness is really, at this stage, is really irregular. And the only reason we can see for them to want that is the possibility that the witnesses could be intimidated at this early stage, particularly when the cross-examination can become very antagonistic. Normally, in a regular trial, the judge will protect or will help protect the witness from undue aggression of any of the counsels. But this is not a trial. This is just really an administrative proceeding to determine if there's enough evidence to go to trial in the Senate. So that is what's happening with Justice Sereno's impeachment complaint now. Is there any question on Justice Sereno? I will say thank you. Yes. Okay. So the other thing that we wanted to talk about today was, well, what was happening in the Office of the Ombudsman. I made a mistake today and I said that the President retains the right to discipline from the Deputy Ombudsman and downwards, but I misread the decision. The decision actually says that it is after the deputy, so they have the Ombudsman, Deputy Ombudsman, and then everybody after that, the President retains the right to discipline. Why does the President have the right to discipline? because he is the head of the civil service. As the president, he is the highest ranking member of the civil service, and he has supervision and control over all other all other ranks in the civil service. So what does that mean? Also, as the authority, you have the power to hire and fire if you're the employer, and you included in that power is the power to discipline. The power to discipline includes the power to investigate, and the power to investigate means that you get to determine if the facts will constitute an administrative offense that is punishable. So there are several kinds of administrative penalties. There are suspensions. In some proceedings, there is censure, like in cases before the National Historical Commission on violations of the flag law or of the violations of the flag and heraldic code. They're pwedeng censure lang. In others, there's suspensions, different kinds of levels of suspension. There's 1 or 2 days, and there's one for several months, up to 6 months, and onwards. And then there is, of course, removal from office or dismissal from office, depending on how grave your administrative offense is. And in some cases, how many times you've committed it. Because you get, for the lesser offenses, sometimes you can get 1 or more chances. Now, the question here is the president allowed to make an administrative body to investigate, to look into it? Well, yes, of course. From the level of let's say, the state prosecutors, which is after the deputy ombudsman and onwards, the president retains the power to discipline. And part of the power to discipline is to investigate. So it is up to the president to determine how he's going to investigate, and one of those ways is to form a panel to look into it and determine factual matters. In the revised in the revised rules on administrative procedure, the head of agency can issue a show cause order. I can issue an order asking the respondent to explain a certain situation or certain facts that have been raised about him or certain issues. And then he answers, and then the head of agency can say, okay, this will go into investigation. And then he can assign somebody to create the investigation. And in that investigation, there's an opportunity for the respondent to give his or her side. Or if there is a complainant, then the head of agency can determine if the complaint is sufficient. If it is, then it goes into investigation. And then after investigation, you can make a determination of if there has been an offense and what penalty can be imposed on that. So in this case, the Supreme Court has already said that for state prosecutors and special prosecutors and downwards, then the president retains the right to discipline. Now, what about the deputy ombudsman? The Supreme Court has said that the deputy ombudsman is under the administrative jurisdiction of the ombudsman herself. But do remember that these are for administrative cases. What happens